Medical marijuana regulators continue to work on a permanent set of rules for the industry. At the same time, a medical marijuana patient is challenging a law passed by the legislature to protect her job.
This was the final week the Oklahoma Medical Marijuana Authority accepted public comment on its proposed permanent rules for regulation of patient licenses in cannabis businesses. The move is necessary because the current emergency rules in place will expire before House Bill 2612, known as the Oklahoma Medical Marijuana and Patient Protection Act, or Unity Law, takes effect. Even that is now facing a legal challenge. Despite what the lawsuit might mean for future regulations, the OMMA is continuing forward with the proposed permanent rules.
So what those do, they don't make any statutory changes. They simply kind of clarify some of the language in our emergency rules, add some detail in certain areas. For instance, defining a rejected application versus a denied application, things like that.
Minor changes have been made between the emergency rules and the permanent rules being considered. Now that the public comment period has ended, the OMMA will review them and create a finalized proposal.
After that, by April 1st, we will provide information about the public comment we received in our responses, both publicly and on to the Secretary of State, the Governor's Office, the legislature.
The final decision will be in the hands of lawmakers and the governor.
And if approved and the governor signs them and the legislature approves them, they will become effective upon the governor's signature.
Oklahomans for Health Chairman Chip Paul feels when House Bill 2612 is enacted 30 days after the legislative session ends, that a complete set of regulations will take root and give both patients and cannabis business owners a clearer picture. Instead of crafting a new medical marijuana law out of whole cloth, the lawmakers are instead creating a regulatory framework within the Unity Law that is in the spirit of State Question 788.
And they went so far as to respect, our wishes under 788. So the regulatory that lawmakers have built in the Unity proposal and now Unity Law is a proper regulatory, but it's the regulatory that we really worked on all last summer and fall with lawmakers.
The Unity Law will bring with it standards for testing, labeling, and packaging, and is welcomed by those working within the industry to help them deliver a safe product to patients.
So I think that everybody in the industry is very glad that we now have a proper set of laboratory standards and a proper labeling standard to go by. I think everybody in the industry was very pleased to see that put forward.
As the industry matures in Oklahoma, changes in regulations should be expected.
As we sort of get into this, as we operate the program longer and longer, those regulations, will be more and more specific, I would say. And so then is when you really kind of get into a lot of arguments about how specific regulations are. But frankly, right now, they're pretty common sense.
However, the Unity Law is being challenged by a registered nurse who is also a medical marijuana patient and a cannabis business owner. Candle Law Group partner Colin Rocket is one of the nurse's attorneys.
Correct. We're challenging a number of portions of 2612 or the Unity Bill for various reasons.
One part of the legal challenge is aimed at the OMMA's increased authority to revoke or suspend the licenses of marijuana businesses. Rocket says the language is simply too vague.
We're challenging that because it's void for vagueness. It's not specific enough to apprise commercial license holders of what would actually qualify to have their license suspended, revoked, or be a violation of their license.
The safety-sensitive job list, with no due process to justify the use of cannabis, also adversely affects his client.
The safety-sensitive job issue comes down to the fact that it allows for an employer to fire an employee on the basis of a positive test for marijuana. When you do a urinalysis or a hair follicle or even a blood test, THC stays in your system for a lot longer than the time period in which you're intoxicated.
Rocket says the standard should be higher than what is currently in the Unity Law.
And it's not specific enough in the Unity Bill to require that they actually be intoxicated. There needs to be more than just a positive test. You need failure to perform duties, somebody's acting intoxicated. There needs to be something else.
Rocket says his client isn't trying to get money from the state. She simply wants the regulations to be fair to patients and businesses. In the meantime, OMMA is preparing for the Unity Bill to take effect.
We are assembling a project management team. They will be looking in a more detailed fashion at the timelines, the costs, what the steps we'll have to do to implement those changes as prescribed by law.
As a matter of standard procedure, the OMMA is not commenting on the pending lawsuit.